Hello, I'm David Hardesty, and in this lecture we study the U.S. domestic tax rules for classification of aliens as either residents or non-residents. An alien is considered non-resident unless the person meets the tests for resident alien status. Accordingly, this lecture focuses on the tests for resident alien status. The objectives of this lecture are to understand the following tax rules: the green card test for resident status, the substantial presence test for resident status, the exceptions to the substantial presence test, the beginning and ending dates for resident alien status, dual status aliens, the spousal elections for resident status, the elections regarding first-year status, and the impact of tax treaties on residence status. Resident aliens are taxed in the United States on their worldwide income, while non-resident aliens are taxed only on U.S. source income. Accordingly, it is very important to distinguish between these two types of taxpayers. An alien is a resident alien of the United States if he or she meets one of the following two tests. The person meets the lawful permanent resident or green card test. The person meets the substantial presence test. Let us first discuss the green card test for residents. Under the lawful permanent residence test, or the green card test, an alien individual is a resident of the United States if the person is lawfully accorded the privilege of residing permanently in the United States as an immigrant in accordance with immigration laws. Let us now consider how resident alien status is terminated if such status is based on the green card test. Once this test is met, the person remains a U.S. resident until permanent resident status is revoked, such status is administratively or judicially determined to be abandoned, or a person commences to be treated as a resident of a foreign country under the provisions of a U.S. tax treaty with that country, and then notifies the IRS of the commencement of such treatment without waiving the benefits of such treaty that are applicable to a resident of a foreign country. Under most U.S. tax treaties, a green card holder is a U.S. resident, but if he or she is also a resident of the other country, then the residence is determined by a tiebreaker rule, under which the person will be deemed a resident of the other country if the person has a permanent home in that country but not in the United States. Here's an example of the green card test. Alfredo, a citizen of Italy, was granted permanent U.S. resident status by the U.S. government in 2008. Immediately upon obtaining that status, he became a resident alien of the United States. He spent all of 2010 in Italy. Despite the fact that he lived in Italy, he remained a resident of the United States during that year. Let's follow the previous example into 2011. In 2011, while still holding a green card, Alfredo establishes his permanent home in Milan, and he gives up his residence in the United States. Under Article 2A of the U.S.-Italy Tax Treaty, once he established his permanent home in Milan, his U.S. residence status is terminated, but only if he provides the proper notification and waivers to the IRS. Note that the same result would have been reached if he had officially surrendered his green card to the U.S. Immigration and Naturalization Service. A person can be treated as a resident alien of the United States if his or her physical presence meets the substantial presence test in the Code. The substantial presence test for resident alien status is normally met when the taxpayer is present in the current year for at least 31 days and the special 183-day test is met. The 183-day test is met if the sum of the days present in the United States during the current year plus 1/3 of the days for the immediately preceding tax year plus 1/6 of the days for the second preceding tax year equals 183 days or more. Equals 183 days or more. Here's an example of the substantial presence test. Bjorn, an alien individual, is present in the United States for 122 days in the current year. He was present in the United States for 122 days in the first preceding calendar year and for 122 days in the second preceding calendar year. In determining his status for the current year, Bjorn counts all 122 days in the United States in the current year, plus 1/3 of the 122 days in the United States in the first preceding year, and 1/6 of the 122 days in the United States during the second preceding calendar year. The total of 122 plus 122 divided by 3 plus 122 divided by 6 equals exactly 183 days. Therefore, Bjorn meets the substantial presence test and is a resident alien for the current year. Even though a foreign individual may meet the substantial presence test in the current year, the person may be able to defeat resident status. As an exception to the substantial presence test, if the taxpayer is present for less than 183 days in the tax year, has a tax home in a foreign country during the year, and has a closer connection to that country than to the United States, the person is not a U.S. resident. A foreign individual claims exemption under the closer connection exception by filing Form 8840 with his or her personal tax return or by filing the form with the IRS if no personal tax return is filed. The taxpayer has a closer connection with the country with which there are more significant contacts, such as a permanent home, family, personal belongings, cultural and religious organizations, personal bank accounts, driver's license, voter registration, and country of residence designated on documents filed by the individual. The closer connection test is not met for a foreign country if the person has a pending application for permanent residence status. Here's an example of the closer connection exception. Chow is a citizen of country X and under the substantial presence test is considered a U.S. resident alien. However, in 2010, Chow is present in the United States for only 175 days. Moreover, Chow has a tax home in country X. Chow's family is in country X, and he votes in country X, and his banking and cultural relationships are in country X, and all of his furniture and most of his personal belongings are in country X. Under the closer connection exception, Chow can claim exemption from resident status. He must file Form 8840 to do so. Here are some additional exceptions to the substantial presence test. Canadian and Mexican commuters. A person regularly commuting from a residence in Canada or Mexico to a job in the United States is deemed not present in the United States on any day on which he or she commutes. An alien individual is not considered present in the United States for purposes of the substantial presence test on any day that the individual intends to leave the United States but is unable to leave because of a medical condition or medical problem which arose while the individual was present in the United States. The medical condition exclusion is claimed on Form 8843. An alien individual may exclude, for purposes of the substantial presence test, days of physical presence in the United States if the individual is in transit between two foreign points and is physically present in the United States for fewer than 24 hours. Diplomats, employees of international organizations, and their families. Foreign government-related individuals, including diplomats, employees of international organizations, and their families, are considered temporarily present in the United States, regardless of their number of days of presence, and are not U.S. residents. For example, a foreign government employee of the United Nations stationed in New York is not a U.S. resident, even if the assignment has lasted for many years. Teachers, trainees, and students. If individuals are present in the United States as teachers, trainees, or students, then their presence is not taken into account for the purpose of determining if they are U.S. residents. These are individuals present under specific types of visas who comply with all the provisions of those visas. The exception for a teacher or trainee is lost if the person has been present in the United States for at least 2 of the 6 preceding years. Where this exemption applies, it also applies to the person's immediate family, including spouses and unmarried children under 21 who reside in the person's household. Certain professional athletes and persons on NATO visas are also exempt. Let's talk about the residency start date. That is, the date the person starts being treated as a resident. Under the general rule, an alien individual who was a U.S. resident during any part of the preceding calendar year and who is a U.S. resident for any part of the current calendar year, under either the green card or substantial presence test, will be considered a resident alien at the beginning of the current year. If an alien meets the lawful permanent resident green card test and is treated as a resident alien and was not a resident in the previous year, the question is, when does resident alien status begin? If the taxpayer meets the green card test at any time during a calendar year, if the taxpayer meets the green card test at any time during a calendar year and does not meet the substantial presence test for that year, then resident status starts on the first day in the calendar year on which the taxpayer is present in the United States as a lawful permanent resident. That is, resident status starts on the first day that the taxpayer is present in the country with a green card. Note that if in the unlikely event the individual obtains a green card in the calendar year, but is never in the United States during that year, then residency does not start in that year. Here's an example of the residence start date based on the green card test. Rodrigo has never been a resident of the United States. He moved to the United States on October 1, 2010, and remains in the United States through the end of the year. On December 1, 2010, he receives his green card. He does not meet the substantial presence test in 2010. His resident status begins December 1, 2010, the day on which he is first present in the United States with a green card. If an alien meets the substantial presence test and is treated as a resident alien and was not a resident in the previous year, the question is, when does resident alien status begin? If resident status is based on the substantial presence test with respect to any taxable year, and the person was not a resident in the previous year, then resident status starts on the first day the person is physically present in the United States during such calendar year. Solely for purposes of determining the start date of resident status under the substantial presence test, an individual can ignore up to 10 days of actual presence within the calendar year if he or she had a closer connection to a foreign country than to the United States, and the person maintained a tax home in that foreign country. See Form 8840 for required disclosures relating to a closer connection. To exclude up to 10 days of presence, the taxpayer must attach Form 8840 to his or her tax return for the relevant tax year. The requirements for that statement are set out in Publication 519. In addition, solely for purposes of determining the termination date of residence under the substantial presence test, up to 10 days of presence in the United States can be ignored in determining the final day of U.S. residence if the person has, during this 10-day period, a closer connection with a foreign country. Here's an example of the residence start date under the substantial presence test. Ivan is a citizen of Russia. He came to the United States for the first time on January 6, 2010, to attend a business meeting and returned to Russia on January 10, 2010. His tax home remained in Russia. On March 1, 2010, he moved to the United States and resided there for the rest of the year. Ivan is able to establish a closer connection to Russia for the period January 6 to January 10. Thus, his resident status starting date is March 1st. If the taxpayer meets both the substantial presence test and the green card test, then the resident status starting date is the earlier of the first day during the year the taxpayer is present in the United States under the substantial presence test or as a lawful permanent resident. Flores has never been a resident of the United States. He moved to the United States on March 1, 2010, and remains in the United States through the end of the year. On December 1, 2010, he receives his green card. He meets both the substantial presence and green card tests in 2010. His resident alien status begins March 1st, 2010, which is the earlier of the days on which he would be considered a resident alien under either the substantial presence or lawful permanent residence tests. Here are the rules for determining the date an alien status changes in the last year of residency. If an alien stops being treated as a resident alien in the year, then if residence was based on the substantial presence test, the person stops being treated as a resident on the day following the last day of physical presence in the United States. If residence was based on the lawful permanent residence test, then the person stops being treated as a resident on the day following the day the person ceases to be a lawful permanent resident. Both of the above rules are subject to the following requirements. For the period after which residence is nominally terminated, the person must maintain a closer connection to a foreign country. The person must not be a resident of the United States at any time during the following calendar year. An alien individual who is a U.S. resident for any part of the current year and who is also a U.S. resident for any part of the following year will be taxable as a resident through the end of the current year. Here's an example of the determination of the last date of resident status when residence is determined based on the substantial presence test. Beckman has been a resident of the United States under the substantial presence test since 2008. On October 15, 2010, he leaves the United States and does not return. His resident status terminates October 15, 2010. When resident status changes during the year, an individual can be dual status for that year. A dual status taxpayer is an alien individual that is classified as a non-resident at the beginning of the year and a resident alien or citizen at the end of the year. A dual status taxpayer is taxable for such year as though his or her tax year were comprised of two separate periods, one consisting of the time during which he or she is a U.S. resident or citizen, and the other consisting of the time during which he or she is not. Here's an example of a dual status taxpayer. Jones is a citizen and resident of country X who moves to the United States on April 2nd, year 1, and remains there for all of year 1. Assume his U.S. resident status starts on April 2nd, year 1. For year 1, Jones is a dual status taxpayer and files a U.S. tax return as a non-resident alien for the period January 1st to April 1, year 1, and files a separate return as a U.S. resident for the period starting April 2nd to December 31, year 1. Two different elections permit married non-resident aliens to elect resident status. These are the Section 6013G election by a non-resident alien spouse of a U.S. citizen or resident to be treated as a resident alien, and 6013H, which is a spousal election to be treated as a resident for the entire year. Here is the 6013G election, where a non-resident alien is married to a U.S. citizen or resident at the end of the year. The two spouses can elect for the non-resident to be taxed as a U.S. resident for the entire year. This election permits the couple to file a joint return for the year. Absent this election, a non-resident alien cannot join in a joint return. Here's an example of the 6013 election. Wendy, a U.S. citizen for the entire tax year 1, is married at the end of the year to Harold, a non-resident alien individual. They can elect on the year 1 joint return to treat Harold as a U.S. resident by filing the statement of the election with that return. And if they both agree to the election, if they make the election, income from sources within and without the United States received by both of them in year 1 and subsequent years must be included in gross income for each year unless the election is later terminated or suspended. While Wendy and Harold must file a joint return for year 1, they may file joint or separate returns for subsequent years. Here is the 6013H election. If an individual is a non-resident alien at the beginning of the tax year, but is a U.S. citizen or resident at the close of such year, and at the close of such year, the individual is married to a U.S. citizen or resident, the spouses can make a 6013H election for that individual to be treated as a U.S. resident for the entire year, thus permitting both spouses to file a joint return. Here's an example of the 6013H spousal election. Robert is a non-resident alien at the beginning of year 1 and is a U.S. resident at the end of year 1. Catherine is a U.S. citizen for all of year 1. Absent a 6013H election, Robert will be a dual status individual filing a separate non-resident return for the first part of the year and a regular U.S. return for the second part of the year. If they both make this election on a joint tax return for year 1, Robert will be treated as a resident alien for the entire year.
When a foreign person becomes a resident in a year, it is sometimes advantageous to claim resident status for at least part of the previous year. A special election allows a foreign person to do so. This is known as the first-year election. A person can elect resident status for part of a year that immediately precedes the year in which the person meets either the green card test or substantial presence test. To make this election for the preceding year, the person must have been present in the United States for at least 31 consecutive days during the previous year, and the person must have been present at least 75% of the days, beginning with the start of the 31-day period and ending on the last day of the year. When the election is made,
U.S. resident status begins on the first day of the 31-day period. For purposes of the 75% test only, up to 5 days absence from the United States may be treated as days in the United States. For both the 75% test and 31-day test, days on which the person was present as a diplomat, employee of an international organization, teacher, trainee, or student are not counted if the days are disregarded for the purposes of the substantial presence test. The election is made on the person's tax return for the election year, but may not be made until the person satisfies the substantial presence test for the year immediately following the election year. The election is made by attaching a statement to the tax return for the election year. See Publication 519, page 9 for the requirements for that statement.
Here's an example of the first-year election. Hubert is a country ex-citizen who has never been a U.S. resident for tax purposes. He's present in the United States from November 1, 2016 to December 1, 2016, which is 31 days. He is outside of the United States from December 2nd to December 16, 15 days, and then returned to the U.S. on December 17th, 2016, and remains there through the end of 2017. Hubert is a resident in the following year, 2017, based on the substantial presence test. In addition, he can elect to be treated as a resident for 2016 starting November 1st. Here's why. Hubert was present for at least 31 consecutive days in 2016, and he was present in the United States for 46 out of 61 days, 75.4%, during the period November 1 to December 31. The facts are the same as in the previous example, except that Hubert is also absent from the United States on December 24, 25, 29, 30, and 31, which is 5 days. Under the normal rule, he would have 41 out of 61 days of U.S. presence, which is 67%, which is not enough days of presence in the United States to make the election. However, Hubert can make the special 5-day election to count up to 5 days of absence as days of presence in the United States. And if he makes this 5-day election, he would have 46 days of U.S. presence, 75%, which would be enough to make the election. The next topic is the determination of U.S. resident status for dual resident aliens and the right of a dual resident to elect to be classified as a non-resident alien. Generally, where an alien is resident of the United States and another country, under their respective internal tax laws, that is, dual resident, a tax treaty may allow the individual to elect to be treated as a non-resident alien, overriding the classification in Section 7701B. This election may be available when an alien is classified as a U.S. resident under Section 7701B, while at the same time being classified as a resident of another country under that country's internal tax laws. Such an individual is known as a dual resident. Where a tax treaty applies, The dual resident may elect to apply the tax breaker rules in the treaty to determine residence. In the U.S. Model Treaty, this is Article 4.3. If the alien claims the benefits of the treaty, and if, based on the tiebreaker rules, the alien individual is determined to be a resident of the other country, then the person will be considered a non-resident alien under Section 7701B. The tiebreaker rules involve an analysis of the location of the person's permanent home, vital interests, or nationality. Treatment as a non-resident alien applies only for determining the person's U.S. income tax and withholding. For purposes of the code other than the computation of the individual's U.S. income tax liability, the dual resident individual that claims the treaty benefits is treated as a U.S. resident. For example, the individual will be treated as a U.S. resident for purposes of determining whether a foreign corporation is a controlled foreign corporation under IRC 957. Here's an example of a dual resident treaty election. Bernhard, an alien individual, is a resident of foreign country X under country X's internal tax laws and is a U.S. resident under Section 7701B. In addition, under the tax treaty between country X and the United States, he is considered to be a resident of country X. Bernhard has an 80% interest in Corporation R, a foreign corporation classified as a controlled foreign corporation for U.S. tax purposes. As a U.S. resident, he is a U.S. shareholder of Corporation R under Section 951B, and therefore subject to tax on his share of the corporation's Subpart F income. He can avoid current taxation on this Subpart F income by electing under the treaty to file as a non-resident alien. However, this election does not affect the status of Corporation R as, for example, a controlled foreign corporation.